Hmm.
Okay, so today we're going to talk about lease options versus contract for deed, which I get a lot of questions on this all the time and confusion from our gang. And so I thought I'd go over the differences, the similarities, the tax and legal and practical issues that are make them appropriate or inappropriate depending on the type of transaction you're trying to do. So a lease option simply is a lease plus an option agreement. Some people call it lease purchase. Technically, that's a lease and a purchase agreement, but for the most part, it's a matter of semantics of what you call it, because in the end, it's the same practical effect. So, an option agreement is different than a regular purchase agreement. A regular purchase agreement is bilateral, meaning two ways: seller promises to sell, buyer promises to buy. And if the buyer doesn't buy, is in breach, then in most cases, the seller's only remedy is to keep the earnest money deposit, and then that's the end of the deal. Now, if there's not a provision in the contract that says that, that's called a liquidated damages provision, the seller can sue the buyer, forcing them to buy if they have the means, may not be practical, or simply sue them for damages that the seller may have sustained as a result of the failure to close. So, what is an option? An option is a unilateral agreement, one way. The seller promises and is obligated to sell, buyer is not obligated or promises to buy. It's his option to do so or not do so. It's different than a regular purchase and sale agreement, bilateral, where both parties promise. Now, in effect, it's the same thing, as I said, because if you give the seller some option consideration or money for the option to buy the property and you don't close, you lose your option money. In a bilateral purchase agreement, if there's a liquidated damages provision, which is almost always the case, if the buyer doesn't close, the seller keeps the earnest money, and that's the end. So, as a practical matter, they're the same thing, but often it's just a matter of semantics of how and when we use the vernacular. The optionor is the seller, gives the option to the buyer. Optionee receives that option, that's the buyer. An option is not an interest in real estate. It is a personal property right. It is a contractual right, as opposed to, say, a deed. That's an interest in real estate. A lease is an interest in real estate. It's a possessory interest. An easement is an interest in real estate. A lien, like giving someone a mortgage against your property, is a lien, and that is an interest in real estate. An option is just a contractual right. A contract for deed, on the other hand, the seller conveys what we call equitable title. And the seller is going to remain with legal title, meaning entitled to the property at the county. And the buyer has equitable title, which means they have the right, for all intents and purposes, to own, use, do whatever they need to do with the property, and also pays the principal, interest, taxes, insurance under the contract, and is responsible for all maintenance. Unlike with a lease option agreement, it's a little different. Lease option is landlord-tenant relationship, so if the state law requires you as a landlord to do certain things to make it habitable, you can't delegate that to the tenant. So, for example, a lot of people in lease option agreements say, well, the tenant's responsible for everything. You can't do that, because if state law says you have to keep it habitable, if there is an infestation, let's say, of pests, or a leaking roof, or a non-working heat in the winter, or non-working AC in the summer, those are habitability issues that cannot be delegated to the tenant. So even though in theory you can make the buyer slash tenant responsible for everything, enforcing that is another issue. The seller will convey legal title under a contract for deed when the buyer pays off the balance of the contract. So it's like a car situation where when you buy a car with financing, you don't get the title. The bank holds the title, the lender, until you pay it off, and you get that title. Now, real estate title is a little different. It's not like a document that means anything like a car title, but similarly, the seller will convey by a deed the property from seller to buyer when the contract is satisfied. And that could be done when the buyer refinances, sells the property, or otherwise pays off the balance that is owed to the seller. It is considered a sale for tax purposes, even though title has not passed from seller to buyer. And that's where people get confused. So if you, quote, sell on a lease option, it's not a sale. It's still a landlord-tenant relationship in the eyes of the IRS, because an option is not an interest in real estate. You haven't conveyed anything yet. You've just given the tenant the right to buy it at some point. And when that right is exercised, when that option is exercised, then the property will be conveyed when the tenant pays up the purchase price or the terms of the purchase, and then title conveys, and that's the sale for tax purposes. In a contract for deed, as soon as you sign that thing with the buyer, you've conveyed equitable ownership. So the IRS says you've sold it at that point. What does that mean? Well, if you're taking a small down payment and mostly payments of principal and interest over 30 years, and let's say the buyer on a contract for deed wants to pay you off at year 5, well, then all of the rest of the gain at that point, the balance you receive, is taxable. And which also means you cannot do a 1031 exchange at that point because you already sold it. It's also important when you lease option, whenever you do a lease option, it's a lease, so any required disclosures under a lease under state or local law is appropriate. On a contract for deed, the same thing, anything that would be appropriate for a sale. So in the case of lead paint disclosures or whatever disclosures are required by state law, there's not many in Colorado where we are, where a lot of us are. But in some states, you things like radon. In California, have seismic hazards, or whether you're in a flood zone or things like that may have to be disclosed on a contract for a deed that don't have to be disclosed on a lease. Okay. All right. It's also known as, some people say, what's the difference between that and an installment land contract? It's the same thing. It's just a different name. Bond for deed, bond for title, agreement for deed. I kind of like agreement for deed because that is the easiest way to explain it. We have an agreement. You make me payments. When you pay me off, you get the deed. So I like agreement for deed. Some people call it land contract, which gets confusing because they think raw land, when that's not necessarily the case. So what's the difference between a lease option and contract for deed? First, again, a lease option is not a sale until the tenant exercises that option and pays what's required under the option. And then the seller conveys title, legal title, and now that's when the sale occurs. A contract for deed is a sale from the inception. And for the purposes of disclosure, for the purposes of county documentary transfer tax, and most importantly, for the purposes of the IRS. Now, when you sell on a contract for deed, and you're taking mostly payments over a period of time, that's what the IRS calls an installment sale. An installment sale is good for the seller because you don't pay all the capital gains at once. You pay it over time as you receive the principal payments. Now, you're also going to receive interest. You have to report that as interest income, but the portion of principal you receive, if you've owned the property at least a year before you sold it on a contract for deed, then that principal portion is a long-term capital gain at the rate that was in effect when you sold it, not what it may be in the future, hopefully not higher. Lease option is landlord-tenant. So the landlord-tenant rules apply, and the disclosure rules apply, and the late payment and all the state and local lease provisions apply, where a contract for deed is seller-buyer. Now, they seem similar in that neither party, whether it be a tenant or a buyer on a contract for deed, get the legal ownership, the title, until the balance is paid. However, a contract for deed is a sale from the point of the inception of the contract, whereas a lease option is not until the purchase is completed. Some of the benefits of a lease option allows you to do a 1031 exchange when the buyer buys. So if you own a property, a rental property, and you give someone a lease with option, it's not a sale yet. So when they exercise that option, you can do a 1031 exchange and then exchange those proceeds into another property because, again, it's not sold until the option is exercised. You can't do that on a land contract because you already sold it. And as a practical matter, anytime you do an installment sale, whether it be a regular free and clear property that you're selling or on a wrap using a contract for deed, 1031 exchange really doesn't help you because you can't exchange the note. You can only exchange the cash portion. And since most people are getting, 10% or so or 20% down, there's just not a lot of money to roll over. So when you sell on a contract for deed or any installment sale, the down payment portion is taxed in that tax year. The rest of it is taxed as you receive it over the term of the loan. You still get the depreciation deduction. So if you do a 3-year lease option, you're still depreciating the property as a landlord. Whereas once you sell it on a contract for deed, it's no longer yours for ownership purposes for the IRS, so you can't depreciate it. You also get appreciation on a lease option, and that's assuming the tenant doesn't buy, which is probably the case in more than 50% of the situations, maybe more, depending on the market. If the market is going up in value, tenants tend to exercise options. When the market is flat or falling, they tend to not. And it also depends on how responsible or aggressive or motivated your tenant is to buy the house, which is in most cases low. So if the property goes up in value, they don't exercise the option after 2 or 3 years, then you do another lease option and raise the price. So you're getting appreciation in theory on that. If you've owned the property at least 12 months and then the tenant does exercise the option to buy, and usually I would recommend you do that, even if you just bought it and you sell it on a lease option, you require that the option cannot be exercised for at least 12 months from the time you bought it. That way, it's a long-term capital gain as opposed to a short-term capital gain. And also the potential for doing a 1031 exchange. On a contract for deed, you get a bigger down payment because they're not putting option money down, they're putting a down payment on a purchase of a property. So you tend to get a bigger down payment. You're not responsible for any repairs under any stretch of the imagination. Okay, so it's not a landlord-tenant relationship, it's a seller-buyer one, and that means no responsibility for repairs. So really, when you sell in a contract for deed, it's really hands-off. You're like a lender, you're just collecting payments of principal and interest. Whereas a landlord-tenant, even though you could delegate some authority to the tenant, or responsibility rather, to fix the property, certain things you're required as a landlord to do that are things that make the property habitable. So does a broken screen door make the property inhabitable? No, that was something that's on the tenant. But if the hot water heater doesn't work, yes, that's habitability because they're entitled to have running water. You get a bigger monthly spread. And that's one of the big advantages of a contract for deed, because under a lease option, the landlord's paying principal and interest, taxes, insurance on their underlying loan. Or if they have no loan, just taxes and insurance. The tenant is paying rent. On a contract for deed, the tenant is paying the taxes and insurance in addition to the payment on the principal and interest. So that shifts that tax and insurance burden from the titled owner to the equitable owner, or seller to buyer. So you're getting more cash flow coming in and cash revenue coming in on a contract for deed as opposed to a lease option. It's often also easier, I found, to quote sell. You're not really selling on a lease option, but to get a tenant buyer in, I found it's easier to, when you say, I'm offering the property for sale, owner will carry no bank qualifying, and then someone comes in and gives me a down payment and makes the payments on the contract. I found that's a quicker sale than lease with option or rent to own. rent it with an option, because rent with an option, um, two things. One is the tenant doesn't really feel like the owner of the house, as opposed to on a contract for deed where they feel more like, I own the house. I'm not just a tenant that might own it someday. Um, and also the buyer on a contract for deed, since they are the quote owner under the Internal Revenue Code, they can deduct the mortgage payments as the interest as a principal residence, where a tenant cannot deduct lease payments because they don't own the property yet. So that's a biggie. Some rules of thumb, one versus the other. On cheaper properties, lease option generally works better. Why? Because properties on the lower end tend to rent for more per dollar of ownership value than on the high end, where there are fewer tenants, and thus you're not going to get enough or as much rent, particularly if you have an underlying loan. On a median price property, let's say the median price in your area is 350. On a 350 or 300 house, you could rent it and break even or maybe even positive cash flow. On a $700,000 house in that same city, you're probably not going to get double the rent. So you maybe, instead of getting on the 350 house, maybe you can get 2,500 a month. On the 700,000 house, maybe you get 3,500 a month, and that may not cover the underlying mortgage. So when you sell on a contract for deed, you're going to get taxes and insurance paid by the quote buyer, and therefore you're going to get more revenue coming in. So on more expensive properties, sell on contract for deed. On cheaper properties, it's better on the numbers, at least, not putting other factors aside, like maintenance. It's better to do a lease option. What you may do is, if you own the property a long time, like more than 12 months, and you sell it on a lease option, it's a long-term capital gain if they exercise, when they exercise. On a contract for deed, that's a sale right there. If you've already owned it 12 months, it's a long-term capital gain on the principal portion. But if you've owned it less than 12 months, if you just acquired it and then you want to sell on either a contract for deed or a lease option, what you may want to do is do a lease with option for 12 months with this person. And then when they exercise, the terms of the option purchase is by contract for deed. So you're basically try before you buy with this, not for them, but for you as the seller. Try this tenant before you're going to sell to them, see if they can make the payments and behave themselves, and then sell it to them on a contract for deed when they exercise after 12 months. Then it becomes a long-term capital gain. So it's kind of, getting the best of both worlds. All right. Let's do some Q&A on that and see if anybody has any clarification questions they need.
Morning, Bill.
Yeah,
good presentation. Thank you.
Thank you.
On a contract for deed, since the seller is similar to being a bank, is it good practice to escrow the taxes and insurance as the seller?
Well, if you as the seller have an underlying loan that already has that escrow, then you're just going to collect from the buyer exactly what you're paying. So if your underlying loan is at 3%, and it has a tax and insurance escrow of $500 a month, then you're going to collect from your buyer at whatever amount you sold it on for the note portion, and whatever interest rate, maybe 6%. And then you're going to collect that same $500 a month. So if your payment goes up for tax and insurance escrow, their payment goes up. Now, if the underlying loan does not have an escrow, or you own it free and clear and you're selling it this way, then it's a little different. Then you either going to have to make a decision whether or not you're going to allow the buyer to pay it on his own, pay it annually, or you can decide to take an escrow every month. And that's kind of a pain, because now you have reporting requirements every year. You have to give them an escrow accounting. You may want to use a servicer. There are servicing companies that'll collect the payment and then do reports to everyone, and they're $30 a month-ish, and they'll do all the escrow accounting, which would make it a lot easier.
Okay. If we decided to not use a servicing company and we were going to escrow it ourselves just to make sure that the insurance and that the funds for the taxes and insurance are available when due. Is there any, other than the reporting, is there any other legal requirements for us?
Technically, yeah. Technically, there are federal regulations all over that stuff, just like there are for your lender on your underlying loans. But the basics are you collect what you think is required. You give them a statement, either annually. I think you may have in some states do it monthly, or quarterly. And if it goes up or down, usually up, then you have to give them a new accounting and say it's short, you have to pay this much more or this much to make up the deficit plus more, just like your lender does to you.
Okay. Okay. I have other questions, but I'll back off and let other people chime in, then I'll come back in.
Hey, Bill.
Shoot.
My question is in context of trying to create a win-win where I'm thinking doing a lease option. This may sound a little morbid to allow the senior citizen to basically die. And so the kids will get a step-up basis. But then is there any way to, because I know with the lease option, you lock in the final price of what you'll pay. So any appreciation, you're good. It doesn't matter because
You're talking about from the buyer's point of view now.
Correct, the buyer's point of view. Like
So
I'm
you're
the
going to
buyer.
lease it from someone who's old and then exercise the option from their estate when they die. So, or from the heirs, after the step up in basis.
Well, I guess that's the next question is, does that contract get voided if the person dies, or it's
No.
able to just easily?
If you have a contract with someone and they die, their estate still has to honor that contract.
Okay, really? Okay.
It's
Is
only
there
a
any way
bankruptcy. It's only a
in that
bankruptcy that
contract?
would, yeah, only a bankruptcy would void a contract.
Okay. Is there any way to structure that contract to reduce the final amount per the amount of payment that I've made?
Yes. You could say that in the option agreement that for every payment of lease you make, the option price is reduced by X dollars or 50% of it or 100% of it, whatever.
Oh, okay.
Yeah.
So in that sense, would that be a pretty good strategy to help out both parties?
Sure. Sure.
Okay. I just didn't know if you reduce the final payment, if the IRS just sees like, no, you're trying to like fudge on calling this a sale or not.
That's their problem more than yours. If the IRS says that was really a sale, like if you do a 10-year lease option with a declining balance,
Yeah.
it starts to look like a contract for deed. And the IRS might say, no, you really sold it 10 years ago on a contract for deed, even though you called it a lease option. Again, that's their problem, not yours. But it depends on really how long it goes for and how much monthly credit you're getting.
Got it. So it sounds like you could really have a lease option for as long as the contract is, or however you want it to be.
In theory.
Okay.
There are courts that have said if it looks like a duck and it quacks like a duck, it's a contract for deed,
Got it. Thank you.
Quack, quack. I love it. So let's say I have a house and I sell it to Frank on a contract for deed,
Mm-hmm.
and he's making all the payments. Now I've still got the deed. So can Frank turn around and sell it to you on a contract for deed and I don't know anything about it? I've still got the deed.
That's a good question. So can he buy it on a wrap and then rewrap it, basically? Unless your contract for deed with Frank says you can't, you can. So I put in my contract for deed with my buyers that you cannot do that. The only thing you can do is resell the property for cash. And at that point, there's an escrow with a title or company or escrow company or attorney closing it that'll put all the pieces together, meaning pay off the underlying loan, get the deed from you to Frank, and then Frank to the next buyer all at once.
Okay. Okay. So just make sure that clause is in the contract for deed.
Now, on the opposite side, if I'm buying on a contract for deed, I'll make sure that's omitted so that I could rewrap. I've done that many times.
Makes good sense.
Yeah.
Okay.
Yeah. And on a lease
Thank you.
option, this is interesting. My lease option says that the tenant can only exercise the option to purchase it as his principal residence. Why? Because if he can't buy it and the market has gone way up to the point where the market value is way more than his option price, he may want to have someone else buy it from him and like on a back-to-back closing. And that would kill that because he's not buying it as his principal residence. He's buying it to flip it. Yeah.
Okay.
This just happened to a client I had that where they had a really low option price and they sold it too cheap, and now the buyer is trying to sell it to an investor. But the option agreement said he can only exercise it to buy for his principal residence, so that would prevent that.
Okay. Well, that brings up a thought. If I sell it to somebody on a contract for deed, and well, selling it turns out he's an investor, and then he turns around and rents, is there a undue complication?
It
Well,
depends
we
on
have
how
more
your
people,
agreement, my contract for deed says you can only live there as your primary. You can't rent it out to a third party without permission.
Okay. Excellent. Well, thank you.
Yeah. And again, if I was buying on a contract for deed, I wouldn't want such a clause.
Okay, well, I'll jump back in. um, Squatters have become the hot topic these days, and if I were to do either a lease option or a contract for deed, I haven't given a lot of thought to this, and they vacate it, somebody else, squatters move
Well,
in.
they've already, the way mine's worded, they would already be in violation. They have to occupy it as their principal residence in either case. So as soon
Okay,
as they
so
move out, or either case, lease option or contract for deed, they're in violation.
okay, okay, so they move out, and then do we do a foreclosure or eviction or something to get?
Good question. So on a lease option, eviction always. On a contract for deed, it depends what state you're in. So some states like Florida, you have to foreclose it. In Indiana, you can do what's called a forfeiture proceeding, which is a little longer than an eviction, but shorter than a foreclosure. But once they have more than 20% equity based on the original contract, you have to foreclose. In other states like Illinois, that's forfeiture, Pennsylvania, forfeiture. Colorado doesn't have a procedure. So what we do is, the contract says if you default, we terminate the contract. And now you become a holdover tenant, and we do a holdover eviction. But if we go to landlord-tenant court and they say, wait a minute, this was a contract for deed, I'm not a tenant, the judge doesn't have jurisdiction to hear that issue, so he'll bounce it up to the higher court for a hearing on whether or not that has any merit, and that judge will decide in that court. You can proceed with foreclosure, or you have to go to proceed with the eviction or go to foreclosure.
Oh, I remember in one of your videos you mentioned foreclosure is a higher court,
right? And it's also
eviction.
not a trust deed foreclosure. It's a judicial foreclosure, which takes longer.
Okay.
Now, in a state like Florida, it doesn't matter because they're a mortgage state. But in a state like California, Texas, or Colorado, where trust deed states, where trust deed foreclosures are faster than judicial court foreclosures.
Ah, okay.
Mm-hmm.
All right. Thank you.
Hi, Bill.
Hey, how are you?
Good. So it sounds like if it's like if the property is worth like I have one that I'm looking at, it's a condo. It's about 300,000 in Arvada. That price range you're saying maybe would be better for a lease option versus contract for deed because I could probably then lease it to someone else at a little bit above market. Does that
It
sound about
depends.
right?
It really depends on what the numbers look like.
Gotcha.
With the HOA and your underlying loan, it
Mhm.
depends on, what the numbers look like and what you're trying to accomplish. If you're trying to accomplish, if you want depreciation, if you want appreciation, because most tenants don't ultimately buy, statistically, then you go with lease option. If you say, I want hands off and I want more cash flow, then you go with contract for deed. Because remember, who's paying the HOA on a contract for deed? The buyer. On a lease option, you.
I see. And if I do contract for deed, would I be able to claim depreciation on my taxes because I technically own it?
Nope.
No.
You're
Oh,
you're the
until
legal owner, but you're not the equitable owner. So
gotcha.
you're holding title simply for collateral for payment. So you're a lender.
I see.
You've already
So
sold. Can't claim
so
depreciation.
m- my seller then on under both either lease option or contract for deed, they still get to claim depreciation on their taxes then.
No. On a contract for deed, once it's signed, that contract for deed, it's sold. Therefore, the seller
Okay.
can't claim depreciation anymore.
Okay. But I can't either
Well,
as the buyer.
you either, if you buy it from the seller on a contract for deed, then you can depreciate it if you're a
Okay.
landlord, and then you rent it out.
Gotcha. If I'm a landlord, of course.
Yeah,
Gotcha.
we rarely buy on contract for deed. More often, you just buy it straight subject to where you get the deed, because it's a stronger legal position for you as an owner. But sometimes the seller's a little leery about you just taking their deed and they have no recourse if you default. So sometimes we'll do a contract for deed on a purchase. But more often not, we buy it subject to, just get the title and then sell maybe on a lease option or contract for deed.
Gotcha. So if you do subject to, would I then, I take over the payments, would I give them their equity? Do you normally do that?
That's all in the negotiation. If there's a lot of equity,
Gotcha.
they may want something. If there's a little, maybe not much. Um, if they have, 20,000 in equity, you're probably going to give them nothing.
I
If
see.
they have 100,000 in equity, maybe you pay them 35 or 40 for it cash, or maybe you pay them a total of 70 with 10 down and a note for the rest. I mean,
Okay.
there's
Because I
no,
think this person has less than 100 in equity. She maybe
yeah,
has like 60 or something like
yeah.
that.
So maybe
So
you give her 10 grand for her equity and that's it.
I see. But she could probably get more than if she just tried to sell it with a realtor then, I guess, in that case. I mean,
Maybe,
yeah,
maybe not.
depends on her motivation.
Depends how motivated she is, depends how the property shows, depends
Mhm.
how high the HOA dues are, depends on whether the condo association can even get a loan against
Okay.
it. Because if it's like 70% landlords in the association, there's no lender's going to lend against that.
Gotcha. Okay. Thank you.
There's a lot of factors, a lot of ifs. And plus, if they sell with a realtor, if they're not really getting another 60 in equity, they got to pay the realtor fee.
Which is normally like 7% or something
That's
like that.
5 to 6%.
Okay.
So,
And what other fees? Because like say she only has 60,000 in equity after the 6% for the realtor
well, you
fees.
got closing costs, title policy, and undoubtedly the buyer is going to require some inspection items be resolved and fixed, which is going to cost the seller money. So it depends on the condition of the property.
So usually that would be like maybe another 10 grand or something,
Mm,
roughly.
Give or take.
Okay.
And then there's the convenience factor. Do you want it now, or do you want a bunch of people traipsing through your house and, lowballing you and making offers, and maybe you close it in 2 months?
Hey, Bill, I'm back.
Go for it.
Yeah, yeah. I'm familiar with in a regular, not a contract for deed. I don't know what you call the other sale. Um, but where we record the deed so that the new buyer, it's all recorded. And I hear this phrase, recording or not recording the contract for deed. What does that mean? Because that's a contract.
Well, what you described with the deed is just subject to. On a contract for deed, if you're buying the property, you definitely want to record that with the county. That will prevent the seller from refinancing, taking their equity out more, trying to sell it to someone else. You would also have priority over other liens and so forth. When you sell, we generally don't want to record it. Now, a few states require it, but most states don't. And the reason being that if the buyer defaults on the contract for deed and they just disappear, which most just do, most people don't default and then sit there and say, throw me out. They leave. And therefore, there's no mess to clean up on the title because nothing was recorded. You just change the locks, clean it out, and sell it again. If you have recorded something and they disappear, now you have to do a quiet title action in court to clear up that, equitable title issue. That's why I generally don't like to record it on the buy side. I mean, on the sell side, but I do like to record it on the buy side.
That makes sense.
Maybe you do want to refinance your underlying loan. You can do that after you've sold it on a contract for deed because you have legal title.
Sure. Does if it is recorded and you have to get, I forget the phrase you just used, after they move out, does that judicial procedure take about the same amount of time as evictions or foreclosure?
No, it depends on what county you're in. But if it's uncontested, maybe 2 to 3 months. Depends on what county you're in.
Oh, okay.
Depends on the court backlog.
Okay. But now when we're buying or selling using a contract for deed, is that usually done at a title company, attorney, or someplace else?
A lot of title companies don't like doing contract for deed closings. I do them. A lot of attorneys do them. Sometimes title companies, like in states like Illinois, where it's very common, or Pennsylvania, where they're a lot more common, title companies will do them. But Colorado, it's not that common. California, they do them. They don't use, in Southern California, they use escrow companies, not title companies, to close them. And in Northern California, they use title companies. But they do them there.
Okay. So we just need to figure out what the normal is.
Yep.
Okay. Cool. Thank you.
Actually, no. You don't want to find out what the normal is. You want to find out what you can get away with. Because the normal is no. That's unusual. We can do that. Like, what can I get away with?
And always protect our interests.
Right.
Hey, Bill, is there a difference between closing and title?
Yes. Title refers to the chain of title, the record. Seller to buyer, seller to buyer, seller to buyer, owner to lender, so forth. That's the chain of title. Title also refers to the evidence of ownership. So it's the evidence of ownership and the extent of ownership. So the evidence of ownership might be a deed saying you own the property, but the extent of your ownership may be that you're only holding it for collateral for a contract for deed, because if you add in the contract for deed, you don't really own. The extent of your ownership is only collateral for purposes of the loan, right? So title refers to two things: the evidence of ownership, which is the document, and the extent of ownership, what you actually own. So if you have a lease, that's your evidence of ownership. What is the extent of your ownership? The right of possession for the term of the lease. Does that make sense? Now, some people refer to title as, the deed. And the deed, that's title, that's evidence of ownership, but it's not necessarily the extent of the ownership. It could be that you own it, with no other claims, no liens, no leases, no easements, no nothing, right? That's what we call fee simple ownership. You own everything, the air rights, the water rights. But if you gave an easement to the public utility company, your extent of ownership is fee simple subject to the easement. Does that make sense?
Hmm.
I
So
explain that more in a couple of my courses, the chain of title and then the evidence of ownership and the extent of ownership.
I guess ultimately my question is, are those two separate fees when it comes to buying a home?
Oh, well, you're going to get a title insurance as a fee. That's to insure the transaction. That's to guarantee to the buyer that there's a pocket to go after if the seller gives a warranty that turns out to be broken about the deed, because a deed contains warranties, usually, unless it's a quit claim deed. The recording of the deed itself is a fee, and then I would imagine, I can't think of any county that doesn't, has some sort of transfer tax, like a sales tax on that transfer. In Colorado, it's very nominal. It's $100,000 is $10. In Pennsylvania, it's 3 to 4%. So 3 to 4 grand on 100,000, plus like a $20 fee to record the deed, plus title insurance, which is usually paid by the seller. Not always.
So I guess in states that require attorneys for closing, that would be an additional charge that the attorney would.
Well, there's the closing fee that whoever's closing it's going to charge, to close the transaction. That means prepare the documents, record things, do the closing statement, collect and disperse money. That's one fee. Most closers also charge a loan closing fee if there's a loan involved, whether it be owner carry loan or an institutional loan. Okay. Now, in Colorado, where we are, you get a title commitment, which is basically they search the title and say, here's what we're willing to insure. In states like Florida, attorneys charge for a title examination fee to review that title commitment to make sure everything's in order as it should be. Does that make sense? But attorneys, when they close transactions, generally don't charge a separate attorney fee unless they're preparing documents for one of the parties, like a note or some other document.
Okay, got it.
Hey guys, I've got a question.
Shoot.
Okay, can you hear me?
I hear you fine, Cole.
Okay, cool. So I understand on the investor side, generally how to structure it. I have 2 clients for listings right now,
Right.
and one of them, it's dead, and they're open to potentially selling it with seller financing. Another one, I have a guy from New York. He wants some crazy price. I overpaid for the property. Anyway, long story short, I think they're both going to end up as the possibility to sell that way. I haven't pitched it to them. I don't necessarily want to put myself out there as an agent doing that.
Right.
But what are your thoughts on that? And if so, do I structure it as a wrap or a contract for deed? What would I charge extra? What are just your thoughts on that general situation from an agent standpoint? Backing into essentially they're eating money, stuff's not selling.
Do you have, when you say client, do you have listing agreements with them already?
I have 2 listing agreements.
Okay.
Yes.
All right. Because when people say client, sometimes they're referring to a seller or a buyer. I'm like, nah, don't call them clients.
This is traditional.
You don't know a
listing
fiduciary
as is.
obligation to a seller or a buyer. You do
Correct.
as an agent to your
Correct.
customer. So you'd have to switch hats, which means you'd have to do I don't know if in your area you have what's called the licensee buyout form. We have that in Colorado where it says I'm not acting as your agent and now I'm acting as a buyer, and there's a bunch of disclosures in there, right? So that would be one form, and in addition to that, I would put in the purchase agreement some language to the effect like, well, if we list it and sell it, you might get more. They may not get more, but you might get more. and you're willingly selling it to me at the agreed upon price for whatever reason, and state it: convenience, rush, timing, whatever. That way they can't come back later and say, well, you hoodwinked me. You told me I can get more if you paid me than if I listed it and sold it on the open.
What I think what I'm getting at more is, what if I added to the listing, seller will sell with finance, something like that. As a listing. What would I need to know to
you're not
protect
looking
them
at buying it, you're looking at convincing your client, hey dummy, if you sell it this way, you get more and sell it faster.
Yeah, I would go the first way traditionally, like trying to buy it first, but it's just the numbers are they're weak,
numbers don't.
At least for me.
Gotcha. So yeah, I would just explain to them, what the benefits are and what the risks are. And I put that in writing.
And then do I sell it is it better to sell it in that case as a land contract? Is it better to sell it on a wrap, depending on how would it be structured on the back end?
Yeah,
if someone wants to buy it that way.
I would tend to do it as, where's the property?
They're both in Florida. One's Tampa, one's Southwest Florida.
As I mentioned, in Florida, all contracts for deed have to be foreclosed. Now that's a judicial foreclosure state anyway. So I'd still sell it on a contract for deed because, like I said earlier, if the buyer defaults and then just disappears, there's no title issue. We pretend like it never happened. But if they fight it, then you have to go through foreclosure or buy them out, give them cash in exchange for keys and a release of their ownership interest in the property.
And then what do I need to advise them, I'd say, on the insurance part? If let's say the buyer's buying it on a contract for deed, and now it gets down into the insurance, and they both have underlying loans on the property. So there's
So what I do is, when I'm the owner and I'm selling, I keep my insurance the same, like a landlord-tenant policy, right? If they don't have a landlord-tenant policy, they should change it to one. And then the quote buyer, for insurance purposes, is a tenant, and they get their own, renter's insurance. That's the way I've always done it with my, insurers. That's the way they like it, because title to them is ownership, not equitable ownership, or you know what I mean? They don't make the dichotomy. So I would keep it as a landlord-tenant policy if you're the seller, and make sure that the buyer shows up at closing with a tenant's policy.
Okay, that makes sense. And there's nothing to get nervous about as putting that hat on to help them sell it.
No. I tell you a quick story why this is so important. We put in the contract for deed, it is advised highly, Mr. Buyer, that you get one of these policies in big, bold, uppercase letters. Now we make them show up at closing with it most of the time, but they didn't do that in one case, and there was a grease fire in the kitchen that they did, right? So it did like 40 grand worth of damage, and the titled owner made a claim under the policy. And then the insurance company paid the 40 grand and sued the tenant, quote, tenant, who was really a contract for deed buyer, because the insurance company has the right to sue the party at fault as long as they're not the insured under the policy, and the buyers weren't. So the buyers came screaming, I thought we were paying for insurance every month. And I said, no. Read again. This does not cover your contents. It is highly advised you get a contents policy.
So who won the lawsuit?
There was no lawsuit. As soon as they saw that, as soon as their attorney,
they dropped it.
As soon as I showed that their attorney, they went, yep, all right.
It was done.
It was done.
Cool. No, that helps.
I would really insist and check on it, because it's not just damage to their stuff, it's liability.
Yeah, and that's more because if it's me, I'm okay with covering myself. Now, if I'm advising someone and I'm not an attorney, that's where I'm like, let me make sure. Let me at least ask if it makes sense.
And it's so cheap. We're talking like $180 a year. We're not talking about a lot of money.
Right.
And it covers, like, let's say if you had a homeowner's insurance policy and you lived in the house and your car was broken into, that's covered in most cases. If there's a water flood or whatever and ruins your carpet, that's covered. None of that is covered under the landlord/tenant policy in a contract for deed scenario. The only thing that's covered would be if the house burns down or the roof is damaged, the underlying policy would cover that, but not the tenant's or quote buyer's stuff.
Okay, that makes sense. And if that's the way it goes and I add it to a listing and someone buys it, I'll reach out to you for the details on all that.
Yeah.
So cool.
Okay.
Thank you.
Cool. All right. We're at the top of the hour. So thank you everyone for joining. I hope you enjoyed it. If you missed a few things or you came in late, this is recorded, of course, and you can watch the replay. And have a great weekend. We'll see you all next week. No, 2 weeks. 2 weeks.
Thank you,
Thank you,
Bill.
Bill. Thank you, Frank.
Thanks. Bye-bye.